but the case, Your Lordship, starts at 382. There, my Lord, their Lordships said that the degree is well settled. It must carry a reasonable degree of probabilities, but not so high as is required in a criminal case. If the evidence is such that the tribunal can say that we think it's more probable than not, then the burden is discharged. Then the burden, my Lord, is discharged. Miller versus Minister of Pensions, yes. 382, the holding is at 383. My Lord, which now takes me to the first issue. The admissibility of the affidavit of Ben Mukasantale. My Lord, we have submitted a lot about this issue, so I'll not say too many things about it. Suffice it to say, my Lord, that Chamber Nathan Mwanguzi and George William Maumbe on the 9th of April deposed affidavits in support of the petition. My Lord, those affidavits were filed together with the petition. No, those in support of the petition. Not mine, my Lord, yes. Yeah, of the first respondent, yes, my Lord. And I'm saying, my Lord, that as it became apparent during the examination, they explained to the court the egregious circumstances in which they had shown the second set of affidavits, which were removed from the record of court. My Lord, we have already argued that that which Ben Mukasa did, and is clear from his affidavit, clear from those affidavits which were expunged, clear in the examination in court here, is against the tenets of a fair trial. My Lord, we are dealing... My Lord, now we are dealing with that of Ntali. Yes, that's what I'm saying, my Lord. Yes, no, my Lord, what, the point I'm... Ben Mukasa, my grievance is this, my Lord, that he perpetrated the illegality that the court has identified, that counsel for the first respondent has identified, and has led to the expungement of those affidavits. So my question, my Lord, is, if this Ben Mukasa has denigrated the tenets of a fair trial by doing what he did, by procuring this illegality, by ensuring a fair trial does not take place in this matter, the question then should be, should we allow him to continue participating in this trial? A trial that he does not believe in, or at least its fairness. And as we have already shown you, my Lord, previously when we were arguing that approaching witnesses of the other side is unlawful. And Ben Mukasa has said that. These witnesses came to court and said that. That is illegal, and we have identified that illegality. Now the issue is, should we allow Ben Mukasa to continue being part of this trial? My submission, my Lord, is that he should not be allowed to continue participating in this trial. We have identified an illegality. Leaving his affidavit on the record of court would be to sanction his conduct, to sanction his illegality. That's the effect. If we agree that what he did is unlawful and illegal, then leaving his affidavit on record is sanctioning that illegality, which the Court of Appeal has been very clear about. Don't touch the other side. This man came to court and said in his affidavit that he's the one who did it. As it became apparent in the examination, he did it. It is illegal, and we have identified it. Now, can we keep the illegality on court, my Lord? It is our submission that we should not. My Lord, of course, for that position, I refer to the oft-cited case of Makula International versus Emmanuel Cardinal Amara, His Eminence, my Lord. That authority is at page 449, but the actual holding is at 467. 467 is where the actual holding is. Yes. 467, yes, my lord. Same volume I've been using. The case starts at page 449, my lord. So, my lord, my prayer, therefore, on that affidavit is that it be struck out. Be struck out the courtroom. Second issue, my lord, whether there was non-compliance with the provisions of the PEA relating to elections, and if so, whether the non-compliance affected the result of the election in a substantial manner. My lord, as I spoke earlier, section 80, subsection 1 provides for the grounds for setting aside an election petition. This ground we are dealing with in this issue is section 80, subsection 1A. Section 80, subsection 1A. An election of a member of parliament under that section is set aside where there is proof on a balance of probabilities that there was non-compliance with the provisions of the PEA relating to elections, and that non-compliance affected the result of the election in a substantial manner. My lord, let me preface my arguments on this issue by making two legal points. The first one, my lord, it is irrelevant to succeed, for the petitioner to succeed on this ground. It is irrelevant that the non-compliance or elements thereof are attributed to the winning candidate. It is not necessary, my lord, for the petitioner to succeed on this ground that any elements of non-compliance are attributed to the winning candidate. What the law requires, my lord, is proof of non-compliance, and whether that non-compliance affected the result of the election in a substantial manner. That is why you saw, my lord, throughout all our evidence, body of evidence, we did not attribute the elements of non-compliance to the winning candidate. It is irrelevant. It is not necessary. My lord, that's the decision of the Court of Appeal in Mbaju Jackson. Mbaju Jackson versus Tembo Gideon Mujongu. My lord, we have now shifted to volume 2. Mbaju Jackson versus Tembo Gideon Mujongu and Enala. That decision, there is the first one on volume 2. That is page 469. It's the first case in volume 2 at page 469. But the actual holding is at page 501. The actual holding, my lord, is at page 501. If I could just read, the holding is at 501, page 501. It's just paragraph 93, my lord, where their lordship said that the law does not require that irregularities or unlawful actions be attributed to the successful candidate whose election is challenged. Section 61(1)(a), now 81(a) of the PEA requires the court to be satisfied with two things. First, that there was failure to conduct the election in accordance with the principles laid down in those provisions of the law, and second, that the non-compliance affected the result of the election in a substantial manner. That's the first legal point. Secondly, your lordship, the second point I wanted to preface this argument with is that it is also irrelevant and it is not a plea available to the winning candidate in this case the first respondent, to say that the petitioner may also have committed acts of non-compliance. That plea is not available. It is not a defense, okay, to a charge, to a ground, to this ground, my lord, for the first respondent to allege any sort of malpractices against the petitioner, as the first respondent tried to do so in paragraph 3 of his answer to the petition. My lord, that point of law was also settled by the Court of Appeal in Ngomanjime versus the answer, first of all, yes. Paragraph 3, he attempted to allege that the petitioner committed some acts of malpractice. That is not open to him. It is not even a defense. So consideration of whatever the petitioner may have done is irrelevant to this ground, at least, my lord. And I'm saying, my lord, that that point was also settled in the Court of Appeal in Ngomanjime versus EC and Winvyanyima. Ngomanjime versus EC and Winvyanyima. The authority starts at page 512 in our second bundle, in our second volume,